Welcome, everybody, to the joint veterans endorsement interviews for judicial candidates. On the outset, we would like to thank the formal organizations that are here and sponsors of the organization to make today's events possible. Veterans in Politics, Nevada Veterans Association, and Armed Forces Chambers. We'd also like to extend an appreciation and our additional sponsors and community partners who allow us to ensure a professional, fair, and transparent endorsement process. Judge Jacob Reynolds, Department 29. Judge Mary Perry, Family Division, Department P. Judge Veronica, Department 5. Danielle, candidate for Clark County District Court, Judge, Department 28. And Amanda, Las Vegas Municipal Court, Department 1. Thank you, judges, for being here today and judge candidates. The way this is going to work is we will introduce ourselves and the organizations we were with. You each will have 1 minute and 30 seconds to answer the question. When my hand goes up quickly, that means you have 30 seconds. When it starts going this is the countdown. When we get to 0, your time is done. This is not a debate. Answer our questions. Do not go after your opponent. Please keep the lawyerese for your courtroom and do not duck questions. You are speaking to the people.
My name is Bill Carnes, and I'm here representing Nevada Veterans Association.
Michael McDonald, Veterans in Politics and Family Unification Alliance.
Bradford Carlton, the Armed Forces Chamber.
J.P. Edwards, Armed Forces Chamber.
Frank Friends, Veterans in Politics and Court Observers. Judge, candidate and judge, you will each get 1 minute to introduce yourself and tell us who you are and why you're running.
Good morning, everyone. Am I good? Good morning, everyone. Thank you for having me. My name is Lance Hendron. I'm running for Henderson Justice Court Department 3. I've been a Southern Nevada resident for roughly 35 years and have been practicing in Southern Nevada for a little over 18 years. Also wanted to just make with my time just a brief appreciation to our servicemen and servicewomen, in particular those serving right now in areas of conflict and those that we've lost life with. I just wanted to extend my grateful appreciation because without them, we wouldn't be in the situation we're in right now. Thank you.
Good morning, everybody. My name is Barbara Schifalacqua. I am your judge in Henderson Justice Court Department 3. I was appointed unanimously in 2023 as the first ever female Henderson Justice of the Peace. And then in 2024, I was elected by the people. And now I'm back for re-election. I am asking for the support of the people because I have a long list of experience that I bring to the table. Before I was a judge, I was a hearing master in the 8th Judicial District Court for protective orders. And before that, I was a prosecutor for over 15 years in the Clark County District Attorney's Office. I thank you for having us here today. I come from a long family of veterans, including my father, grandfather, father-in-law, grandfather-in-law, uncles, sister, brother, and sister-in-law. So thank you.
All right, first question. Bill Carnes, Nevada Veterans Association. How long did it take you to pronounce your... No, I'm kidding.
Fair question.
Based on NRS Chapter 4, what are the civil and criminal jurisdictions of justice court judges in Nevada and those courts, including monetary limits and exclusions on things such as real property titles?
Sure. Thank you. Or do you want me to start? Okay. Thank you so much. And so Justice Court hears both civil and criminal cases. I do that right now. Our jurisdictional amounts for formal civil matters are $15,000. If it's more than that, it goes to district court. And our small claims is $10,000. Obviously, if it's more than that, they can go for formal civil. But then if it's more than that, it goes to district court. We also hear eviction matters, and we also hear civil traffic infractions. That's the civil side. And we also hear for civil protective orders, but that are not domestic related, because those domestic related ones go to family court, 8th Judicial District Court. So we hear stalking and harassment. With regard to criminal, we hear every case that is a misdemeanor that's not within the municipal court, and then every gross misdemeanor and felony through its inception through preliminary hearing. The jury trial is held in district court. Thank you.
And just to supplement some of that information, as well. So with regards to the preliminary hearing, think of that as a probable cause hearing. In that situation, the justice of the peace isn't determining whether somebody's guilty or not guilty, but whether there is slight or marginal evidence, at which point, if there is, then it would be bound up to a district court for a jury trial. Additionally, our state, not too long ago, does allow for jury trials in misdemeanor offenses that are battery, domestic violences. And the rationale behind that, our Nevada State Supreme Court said when there's an issue of an individual losing their right to a firearm pursuant to state law, that it's serious enough that it would allow individuals to have a jury trial for these misdemeanor battery domestic violences. For all other misdemeanor offenses, the justice of the peace would determine whether the individual is guilty or not guilty.
Michael McDonald, VIPI. So one of the questions I have is in regards to veterans treatment in court. There is a lot of domestic violence issues. We're all human, and I ask, what do you guys do to have empathy for people and for veterans that are going through domestic issues or where they can lose their gun rights, or do you guys weigh the evidence, and is it a high set standard, or can you dismiss it before it goes and gets bound over to the district court?
Do you want me to begin? Sure. Thank you. And so the charge that comes before us, if we are seated to hear that either as a bench trial or a jury trial, of course, that evidence comes from the prosecution. If you're asking whether or not someone is eligible for veterans treatment and treatment with regard to domestic related issues from their service, that's an absolute yes. But that comes to the negotiation process, right? So we can, and I have, my court does not have a veterans treatment court, but Henderson Municipal Court does. So I transfer cases there that folks can apply to be able to be treated through that treatment court, and that includes all types of crimes. But it's not something that unilaterally the judge would make a determination on. Now, if there is treatment, of course, that's part of something that we can order. But whether or not, as you said, it stays as an adjudication or not, if it's presented before us, of course, we have to hear it as a bench trial and find if the state has made their burden of proof beyond a reasonable doubt, or if a jury is impaneled, if they meet that burden, then those consequences fit.
And with regards to the Veterans Court, as indicated, there is no Veterans Court specifically in Henderson Justice Court. There is in Las Vegas Justice Court, our district court, and also our municipal court. That would be one of the things. I understand there's a transfer process from the Henderson Justice Court to other jurisdictions, but looking to see whether or not there's potentials for grant funding or something to further expand for assisting our veterans who may be going through post-traumatic stress disorder, substance abuse, other mental health issues. I think it's very important that we acknowledge our servicemen and servicewomen. And so in light of that, too, I think it's also important that it's known when the individual who's been accused of an allegation also informs both their defense attorney and the state, the prosecutor, that they are a veteran and have served our country. I do think that is important. And the specialty courts that are in place, they differ from jurisdiction to jurisdiction. Usually you're looking at about 12 to 18 month long process. And also it may give those individuals a second chance opportunity where the case themselves potentially could be dismissed if they successfully complete all the requirements of Veterans Court, or have it reduced and also look at getting their record sealed immediately. Because again, we understand the issues that the veterans do face and giving them an additional opportunity. Thank you.
Bradford Carlton, Armed Forces Chamber. I'd like to take you back to law school for a second. In criminal law, we learned that the two purposes of the criminal justice system were rehabilitation and retribution. I'd like to know what your opinion is. Which is it?
That's a very interesting question, and I think it comes on a case-by-case scenario. So, for instance, I've been a criminal defense attorney for 18 years. And, typically some of the responses I'll get is you represent those people, and giving perhaps some grief as far as the individuals that I do represent. What I can say is I have a wife, 2 daughters. My parents still live on the border of Henderson and Vegas. I greatly care about their safety and welfare. I greatly care about law enforcement and being able to do their job, but I also want to have a compassion aspect to where if there are individuals who may have made a mistake in their life, if there are alternatives to incarceration. It's a case-by-case scenario, but I can tell you I've had great success with individuals who have gotten to specialty courts like drug court, completed it successfully. One of them now is one of the main guys running over at Crossroads recovery facility, and I also go work with Shine a Light going in the tunnels here in Southern Nevada. 600 miles of flood channels, about 15 to 1,800 individuals with homing displacements, trying to help get those individuals out. People are dealing with some very difficult times in their life. No driver's license, no social security cards, no insurance. If we can get them on the right path, get them rehabilitated, it helps our community out as a whole. Thank you.
Question of retribution or rehabilitation, it's both. Absolutely. Because you can get to a point where you hold someone accountable, but it doesn't mean that their path is closed to not be able to be rehabilitated, right? But they have to be able to face consequences for actions of their own choosing. Now, maybe some of those consequences are suspended to see if they can follow up and get treatment, etc., that goes forward to be able to change their lives around. I always say this to folks that stand before me, especially if they complete what I've ordered them to do. I always say, I mean this in the nicest way. I hope I never see you again, right? That's the goal. But it doesn't mean that we forget that people are accountable for what they do, specifically if it involves victims of crime, because we cannot ignore one half of that equation. And so I think you have to look at a particular individual and the circumstances of this case and absolutely have both on the table.
Good morning, J.P. Edwards, Armed Forces Chamber. Shut up, Frank. So we understand we've gathered your background. We've gathered your work leading up to this point where you're at. What qualities do you believe make someone an effective municipal court judge? Starting either way, doesn't matter, both.
Sure. Well, I'm a justice court judge, but what makes what qualities that I think in any judge are, first and foremost, you have to be hardworking. I think you have to be able to communicate, including listening, because you have folks that stand before you and you have to be able to make an analysis. You have to be dedicated to doing just that. It is absolutely vital that you spend time knowing statutes, what case law says, and being able to apply them, which gets me to one of my most important qualities I think you have to have, and that's transparency. You have to be able to make a record of what you do. Half of the people in every day that stand in court before me aren't going to be happy with my decision. And that's all right. That's what I've signed up for. But what they can respect is that I have followed the law and that I have given them specific reasons that I did what I did. And that becomes one of the most important qualities as a seated judge.
Certainly, preparation is a given. Anyone that's running and is ultimately elected, they owe it as a public servant to be prepared for all of the cases that come in front of them. Specifically, the Justice Court is what I consider to be the People's Court. And what I mean by that is, in addition to the criminal cases that we're talking about, we've also alluded to the civil cases, protective order hearings, the evictions with the landlord-tenant issues. And what I think is important is that for the People's Court, the Justice Court judge, also be extremely community engaged. They're out there with the people, and they also give the people background as far as how the process works out. Because at the end of the day, for some of these civil matters, a lot of the times, these individuals are going to come in Henderson Justice Court. They would come before me, and they don't have an attorney. So to understand the process and making sure that there is things available to them so that they understand the process. For instance, in the downtown Las Vegas courthouse, we do have what's called the Self-Help Center that works in collaboration with the Legal Aid Center of Southern Nevada. I've participated with the Legal Aid Center of Southern Nevada. We've given Ask a Lawyer sessions, things for the landlord-tenant issues, having brochures and material available, which I think are extremely important. So that way, when the individuals come before me, they at least have a general layout of the land, because this may be their first and only time in the court, and it can be a very intimidating process. So just making sure that they have that opportunity to understand it makes it more efficient for them and the community at large.
Frank Friends, Veterans in Politics. So on average, the American person will see a judge or have 11 charges before they commit their first murder. You see these constant soft on crime judges who are letting people out. You got random stabbings on the streets, New York City buses, things like that. You guys will see these people 11 times before they commit their first murder. At what point do you get rid of the rehabilitation and actually throw the book at them? Because statistically, if you were to do that early and they were to stay in the prison to the age of 27, they don't recommit crimes after that age. Both of you.
Thank you, Mr. Friends. And that's a serious question in trying to analyze and figure out what the appropriate response approach is. I can tell you from watching other candidates' interviews, I look specifically at District Attorney Steve Wolfson's, one of his responses, which says that roughly 10% of the individuals can commit 90% of the crimes. And to focus on those individuals where you have recidivism and where you have violent offenses that are committed before the court is an extreme concern. But I think we also have to have that ability to balance, if you will, individuals that may be there on their first time and being able to figure out what alternatives may exist so that way they aren't recidivists, that they don't come back into the community to reoffend. It's a case-by-case scenario. Justice court is somewhat limited because we don't have a scenario where these individuals would be going to prison. That would be an issue addressed in the district court. But certainly it starts out at the justice court level if an individual is going to be a recidivist individual. And I can tell you at least, looking at cases at large, if somebody's routinely committing crimes and we've given them the opportunity and that hasn't addressed, then at that point in time, there may be no other alternative than that punitive component of being placed in jail. And for justice court cases and municipal court cases, they carry up to 6 months in jail. Thank you.
Thank you. When you talk about putting someone in prison, of course, that's a sentence of imprisonment. But what justice court is responsible for, and what I take very seriously when we talk about letting folks out, is we deal with bail. So I and my court here have bail hearings every single day, 365 days a year. In fact, I'll have them tomorrow morning. I work every single weekend. And what we absolutely look at is an individualized bail hearing. And we look at a Nevada pretrial risk assessment, and that includes their prior charges. And the statutes indicate that I absolutely can, and I will tell you, I do consider their history as to the bail setting. Now, obviously, Nevada Constitution affords everyone a right to bail unless it's a first-degree murder. But there are definitely ways in which justice court judges that hear and see that folks that are back before them with a very lengthy criminal history, that they can absolutely be a part of stopping that cycle, because your job, as I see, as mandated by the Nevada Supreme Court, is to enforce the least restrictive means to protect the safety of the community. And it's exactly what I do in my individualized bail hearings.
Okay, Bill Carnes, Nevada Veterans Association. I want to start with you, Lance, and then go to you, Judge. As outlined, let me start over. Outline the authority of the Justice of the Peace role in NRS Chapter 4, such as suspending sentences, ordering residential confinements, or appointing referees, and what restrictions apply, like term limits on suspensions or prohibitions on handling felonies.
Thank you. So again, with regards to the justice court jurisdiction for a misdemeanor offense, it can exceed 6 months in jail and a fine up to $1,000 for each misdemeanor offense. If an individual has multiple misdemeanors, those could run at the same time or they can run concurrent. You did bring up stuff as far as residential confinement, things of that nature. There is the Valdez-Jimenez hearing, which is that bail hearing that was discussed about. And at that bail hearing, taking things into consideration, understanding it's an adversarial process between the government and the individual that's accused, that it's the government that has to show by clear and convincing evidence that there's no least restrictive means available to the individual that's been accused of that crime. There is that pretrial risk intake sheet that comes through. I could say one of the issues in Henderson Justice Court versus the other jurisdictions is actually getting those pretrial risk sheets provided to the parties involved with this. And so one of the things, and I've actually discussed with individuals that work in the county that handle pretrial risk assessments, they're overworked there because they're handling all the jurisdictions. So trying to work with court administrators, seeing if there's ways we can get additional information from the pretrial risk assessments being provided to all the parties in the Henderson Justice Court within a timely fashion is extremely important. So we understand what type of things that you've addressed can be outlined as far as conditions of release.
We absolutely have the jurisdiction within a sentencing guidelines to up to 6 months jail, up to $1,000 fine, or we can obviously order other conditions. Okay, so I can order someone to have no alcohol, to have some type of community service in lieu of the fine. I can order someone to go to different types of treatment programs, as it were, to get a substance abuse analysis, right? And have them come back to my court to see what that analysis says. And then I can order that type of treatment as part of their condition of their sentence. That's sentencing. When it comes to high-level electronic monitoring, as you're talking about house arrest or other things, and bail, we still absolutely have the statutory authority to determine if the least restrictive means to ensure the safety of our community and the return to court are conditions or bail. And so even if we don't find that bail is the least restrictive means, those conditions very well may be. And that includes high-level electronic monitoring. It includes things like, thank you, no driving, no alcohol, no contact with the alleged victim in the case, right? We have the authority to do that in any one of our settings in order to obviously protect the community and ensure that offenders return to court. The NPRAs actually have been coming out. I work in our subcommittee for pretrial, and we've done many, many things, and we get them on every case now. So I'm happy to say that we've addressed that issue. Thank you.
Mike McDonald, VIPI. So I've got a question about, are you aware of the average citizen commits 3 felonies a day? And there should be, being under your purview is that you can dismiss cases, right? When you have a victimless crime or there's a lot of cases I'm sure that comes across the court that can be for judicial efficiency, and instead of bounding it over, you can dismiss it. What conditions would you dismiss low-level crimes or victimless crimes, and also not using bail? As bail is supposed to be as a means to bring somebody back to court, not as a punitive measure to put somebody in jail, so that the city of Henderson gets that money per inmate per day.
Well, I think you're kind of asking two different things, because you're asking whether or not I would dismiss a matter, right? But then you're also asking about bail conditions. Bail conditions, we always look to the least restrictive means. That's our mandate. And in fact, part of that pretrial subcommittee that I'm on, we've looked at ways to get folks back to court. One of the things that we're able to do is, if someone doesn't have the transportation, we're able to provide bus passes to ensure somebody can come back to court. Because I don't want you standing before me later on saying, Judge, the only reason I didn't make it was because I couldn't get there. Right? So we absolutely have come lengths to make sure that we are having people come back to address issues and it not be any punitive measure, because we're not at the punitive stage when we're talking about bail, right? If you're talking about a sentence of imprisonment, that's something else. That's the analysis of the judge to, of course, think about what they think is appropriate towards that case. With regard to just dismissing cases, we don't just dismiss matters. The executive branch, of course, is in this instance, in the criminal side, the district attorney's office, and they see fit to bring charges. Obviously, I am then bound by the law. Can they prove their case? Can they come up with a resolution that I will follow that ultimately gives them a dismissal, maybe, and where they do requirements up front, but the benefit at the back end is a dismissal? We see that all of the time. But I cannot step on their toes, because I don't legislate from the bench, and I don't step on the separation of powers of whether or not they see fit to charge someone or go forward on those charges.
Yes, and like alluded to, there is that separation of powers aspect. So with regards to the dismissals and how cases ultimately come to perhaps some type of what we'd call like a negotiation pretrial. Those are discussed with the government, the district attorney, and then the defense attorneys, and trying to see if there's any kind of resolution. Now, maybe at the end of the day, the government says that perhaps this is a case that we don't believe that we could prove beyond a reasonable doubt. There may be a variety of issues that may have come to light since that initial arrest, which maybe dismissing the case is the appropriate avenue. They can elect to decide that they wanted to dismiss it with prejudice. In other words, it's never going to come back before the court, or without prejudice. But relying on that separation of powers, the judicial branch is somewhat has, for lack of a better term, their hands tied, and that's how it's supposed to be. Those will all go through the government and the defense attorneys. With regards to returning to court, in situations where there's perhaps just status checks on negotiations, pretrial type resolutions, and the defense attorney has good contact with their client, I don't think if there's any kind of contested hearings that those individuals necessarily have to come to court for those very brief hearings, because they've got to work, they got to take care of their family. We don't want to interrupt on that. But anything that would be contested, making sure that there are means available that they do come to court would be something that's important for me.
Bradford Carlton, Armed Forces Chamber. And I'd like to bounce off of Mike's question just a little bit here. So I've heard many judges today say that they are bound by the law, that they are going to follow the law. Are there any circumstances that you can think of that you would not follow the black letter of the law in the interest of justice?
I think from the hypothetical standpoint, no. I think as a judiciary, we're bound by what the black letter of the law is. Now, there may be given times where there's discretion, perhaps is where we're alluding to. So in other words, if a statute says shall, like if a situation arises in district court where it's non-probationable, for instance, then that individual would be incarcerated going to prison. If there's more of the aspect of trying to weigh various factors, such as like with the bail hearing, or perhaps there's arguments regarding if something was violated as far as a condition of the court. I think, 2 ears, 1 mouth. It's really important to listen to what both parties have to say, take that into consideration when making the ultimate decision. But if the black letter says this must be done in this given way, I'm absolutely going to follow the law with regards to that. Anything that carries discretion, it's a case-by-case basis. So it wouldn't be fair for me to just simply say, hey, this is what I'm going to do on this particular matter, because truly every case is different.
The answer is no. There's no time where I'm not going to follow the law. And that's what I've signed up to do. And if our public sees fit that law isn't appropriate, then they have to go to the legislature and get it changed. Again, separation of powers is something that I take really seriously. But we have to follow what we swear an oath to, and that's exactly what I'll do.
J.P. Edwards, Armed Forces Chamber. So prior questions, you both have stated that you're very thorough with your caseloads, understanding what you have in front of you, reading the cases thoroughly so you're prepared. That being said, municipal courts are often very high caseloads. How would you manage your courtroom efficiency?
Thank you. I can take that now. I have a high volume of cases right now. I have 3 judges total in Henderson Justice Court. And in 2024, I don't have my 2025 numbers. We had 14,500 cases that were between 3 judges only. And we don't have any hearing masters or law clerks or anything. We deal with every single one. And that means I work a lot of late nights, absolutely, in preparation for cases. When folks come before me, we're ready to go. I make it very clear that when it's not only arguing or otherwise, that I've read every single thing that has been before the court, and then I ask and give people time to give me any additional information. But you have to balance it. The bottom line is every case file that's before the court is associated with a real person. And so even though efficiency is something that we can speed up on our end, meaning I've read all of the documents, I've read all of the attachments, I've looked at all the case law, when someone has their opportunity in court, they have to be able to be heard. because again, I'm going to ultimately make a decision that impacts their life, whether that's financially or whether that's their liberty interest. And so the efficiency portion is responding and getting orders out timely, which is what I do, and handling them in the quickest manner you can with folks being heard. Thank you.
For nearly 18 years, I've owned and operated my own private legal law practice. I haven't worked for a government agency where there's that benefit of putting somebody new in a seat where, as far as staffing is concerned, those are things that I have to address firsthand. Taking care of not only my clients zealously and having every case and being prepared for court, but also going through the day-to-day grind of operating a business where I also have to work on making sure that the business continues to flourish. I work 7 days a week. I believe the Henderson Justice Court is open Monday through Thursday, but I'm out there every day, whether it's in the courts. I'm typically in court every day, Monday through Thursday. Sometimes there's special hearings in the downtown courts as well that I'll be in court on Fridays. But I'm also trying to play the game of doing all my court matters, and then in the afternoons working on my clients, making sure they're being taken care of, and hearing new clients. So I have a very, very hard work ethic that I would bring to the bench, which I think is extremely important for efficiency purposes. We don't want to have situations where individuals, again, are unnecessarily coming to court because they have their jobs, they have their families, and this includes not only just general people that may be subpoenaed to the court, but also with law enforcement as well. They can either be out there on the field instead of sitting in court protecting our community, or having that respectful time off for the service they have provided for our community during that time frame. Thank you.
So the people's faith in the court system has been basically degraded over the last 2 decades, and especially recently with these social justice warrior judges pretty much commuting people's sentences from the bench. If you were to see a pattern of a judge constantly favoring a sexual proclivity or a race or a religion and constantly taking the recommended sentence that they were given and cutting it in half or just dismissing the case altogether for probation, even though it's a repeat offender, you were to see this type of corruption from the bench, what steps would you take to bring the honor back to the robe? Start with the judge.
Thank you. It's really interesting when you ask what I would do about another judge. We're bound by judicial ethics, and if I saw that there was some sort of impropriety, you have to report that. Obviously, we have judicial canons that if we thought that there was some actual bias occurring, that we have to report it. We're bound to do that ourselves. With regard to the public's view generally of the judiciary, the best thing that we can do is what I do, and that is come to the table not only prepared, but acting without any such bias of the people before us. There are plenty of times where folks don't like sentences or otherwise of judges, and that's discretionary. But what you were talking about is that it's based on something that is totally inappropriate. Someone's, race, religion, gender, sexual orientation, or otherwise does not bear on what a judge's analysis of the facts and the law are, period. And it shouldn't. It should absolutely be about what comes before the court and what the court is supposed to rule on. But it is something that if you saw particular disqualifying factors, we have duties to report if that were the case. Thank you.
Yes, if it was something that came into the context of a violation of a judicial canon or violating law, there is a duty as far as whether even the attorneys have professional rules to abide by as well, and those things would certainly need to be reported. If there's any kind of, bias that's involved, as noted, being on the bench requires the judiciary to come without any preconceived biases and follow the letter of the law. If there are questions, that become discretionary in the context of the individual wearing the robe, and perhaps it's something that doesn't give rise to being unethical, illegal, nothing is shown that there's some kind of issues underlying that could otherwise be reported. It's important for outfits like we have here today, having this transparency, having the judges and the judicial candidates interview, having them scrutinized on maybe some of their rulings. And at the end of the day, those are what are called political questions. And that's where the general public, and that's why it's so important to vote, has that ability to go hear the information that's out there, which you all provide, which is extremely important. Take that into consideration when they ultimately make their decision to vote for their elected officials. Thank you.
Carnes, Nevada Veterans Association. What is your opinion on providing jurors with true and accurate information that fully informs them of their historical right to judge both the facts of the case and the application of the law in a case, such as a fully informed jury, which may include the concept of jury nullification, as opposed to the standard judicially constrained jury instructions used in Nevada courts commonly, where jurors are directed to apply the law solely as directed by the judge without questioning the law's validity or fairness?
Thank you. You know, it's an interesting question because we get things like this from folks all the time. Well, Judge, why couldn't they have known X, Y, Z? And we do that to protect constitutional rights. And so when you say, do I have an opinion of changing that? No, my opinion is I have to follow what the Nevada Supreme Court has obviously laid out as to what we present to jurors so that people have constitutionally protected trials before them. So they don't use inappropriate information to make a judgment call because on something that they're tasked with just there. They're tasked with at that time, in the criminal sense, let's say, at that time, did that person commit the act that the prosecution has alleged they've committed, and have they proven that beyond a reasonable doubt? Now, there are other factors maybe in that person's background or lifestyle that somebody could say, well, if I knew that, maybe I would make a different, have a different conclusion. But the greatest thing about our Constitution is that we protect that because you're there for what happened on that day at that time and not for what happened in the past or some other time. But as far as trying to change what the Nevada Supreme Court has obviously mandated our judges to do, again, I'm following the laws and will continue to do that. Thank you.
With regards to the Nevada Supreme Court and outlining that the judges have to obviously follow the law, one option that's not available is that jury nullification aspect I think that you're addressing. So that would be inappropriate for unethical and could be reported based upon violations of the judicial canons if a judge was trying to somehow elicit or include perhaps as like a jury instruction that you the jurors can disregard everything and then based on what you've heard and not have to follow the law and then just decide what you want to do. There's outlined statutes and again, Nevada Supreme Court cases that don't allow to just simply say, hey, do jury nullification as a juror. I think it's important for the jury to follow the law. There's going to be evidence that's presented. There's no need for them to speculate outside and to apply the law as it is to render their verdict. And that's what the law says. Again, that's what the Nevada Supreme Court has also told us that we need to do. And those are rules that any judicial officer would need to abide by. Thank you.
Michael McDonald, VIPI. So I have a hypothetical question for you guys. Let's say a veteran comes before you in your court and he did something, let's say a DUI or something that was, and there was an OR release and he was able to have conditions put upon him. And let's say there was a violation. Would you guys be able to have that discretion to not throw them in jail or to impose a sentence, or would you give them chances? What is your opinion on the line between sentencing somebody or remanding them or keeping them to be free and be able to have that discretionary power and empathy for that person, and what circumstances regarding whether they are incarcerated or they are kept at liberty?
Do you want me to start? Yeah. Thank you so much. This is something I deal with every week, right? I have folks that come before me that either have sentences that are suspended, they have conditions before my court, and maybe they don't appear and then a bench warrant may issue. There's a couple different scenarios in that. They could then get in touch with their attorney and put a motion to quash on, and then they come before the court. It's before they've been arrested on that warrant, and they say, Judge, can you quash this? Here's the reasons. Here's what's going on. And that's what we listen for, right? Tell me why you didn't come to court. What is going on? Is there something where you haven't stayed out of trouble? You're committing more crime? Then look, that's going to be analysis where you're really facing that suspended time. If you said to me, Judge, here's what happened. So-and-so, my family passed away, which I've had happen, just last week. And I say, all right, have you stayed out of trouble? They have. We're going to give you another chance. When can you get back to court? How can you do these types of things? Even if they're in custody, you can do that. Maybe something has happened that you realize, of course, within your discretion, you're going to give that individual a chance to keep on. And then there are times that there are not. This is their 6th time they haven't come to court. They've told you 100 times they're going to, do what they said that they were going to do. Because accountability at the end of the day, I mean what I say when I say it. So you have to balance, and it's something that I do every week, which is balance the facts that sometimes folks do need additional time to get things together, and sometimes they have to face their consequences.
It's one of those things where it really is case by case, fact by fact dependent. Obviously representing individuals who've been accused of crimes, like you bring up the DUI example. It's important to look as to see, okay, so are they in pretrial status? Have they already entered their plea with an underlying suspended sentence? And what exactly took place to get them to come back before the court in order to deal with the issue that they're dealing with? I think without question, as far as a judicial officer and maintaining the integrity, accountability is extremely important. So what a judge says needs to be followed along with. And if there's scenarios where that particular individual is not following along with it, again, fact by fact, but extremely important that individual, and through their attorney as well, gather all information as to what got them in that given situation. It becomes extremely difficult, like on a hypothetical example that you utilize where you're saying, hey, there was a DUI, let's assume it was a conviction, and then the individual picks up another DUI. Well, as a judicial officer, I'm looking to protect the safety of the community. I need to make sure that community is being protected. And if they're specifically violating these court orders that were conditions of, then they're going to experience that that's not going to be something that would be acceptable in my court. Thank you.
Bradford Carlton, Armed Forces Chamber. So I appreciate you're both candidates running for judge, but you're also both people. So I'd like to know what opinions you have about what improvements we could make in our justice court system.
Thank you. As your seated judge, I got in a couple years ago and I said, great, here's my list, court administrator, let's get this thing done, right? The biggest thing are our processes, especially when we look at, for my court, which we utilize a case management system that definitely can have updating. And it's something that I've been striving to do with my court administrator, and that means getting money from the county, right? And I have to tell folks, we have those realities. We are constrained by funding, but absolutely, when we live in a world where you can tap everything and slide everything and everything's very easy, in my court, you still have to do a lot of things in paper. So we are shifting to e-filing, having different types of access with regard to our pro se litigants, because equal access to justice is really important. But I won't just do that without keeping in mind that folks need to have specific tools in our procedures so that they can properly, specifically if they're not represented by counsel, be able to fill out forms, etc. And we've been working on that actually, and with the county to improve that, because that's our biggest area that I see both in criminal and in civil that we need improvements for with regard to the court's operation. And as a person, that just makes sense, right? Being able to do something online, being able to file something online makes such a difference than having to physically come down to the courthouse and do the same.
Thank you. With regards to improving the justice system through the judiciary, I believe access to justice is extremely important. I've worked side by side for well over about 10 years or so. As I indicated with the Legal Aid Center of Southern Nevada, I'm on their pro bono advisory committee. It would be something that I would look to further expand, again, bringing a lot of the stuff that's in downtown Las Vegas over to Henderson Justice Court, so individuals that are representing themselves have a better understanding of how the process actually works, allowing the courtroom to be open. Anyone can come in and observe if they so wanted to choose, if they're going to be appearing in front of me. And then additionally, I think what improves justice itself is with the voting public electing the most qualified individuals that are out there in the public view. Justice court, again, is the people's court. So making sure that that individual is engaged with the community. Being out there, going to visit with people, making sure that they understand the day-to-day problems, meeting with stakeholders, trying to find out solutions. So perhaps there's also ways that individuals don't even need to cross forth in the judiciary system if there's alternatives. Trying to think if there's things to look aside from potential evictions. Are there things to help out individuals? These various specialty courts and further evolving and developing them. Those are all things that I take highly important and would look further into on day one.
JP Edwards, Armed Forces Chamber. So, looking back, we understand you're both very thorough, knowledge of the law, knowledge of the procedures. My question is not necessarily for you, because you said you work 7 days a week. So, but I'll still ask you the question, but also for you, Mr. Hendron, when it's all said and done, the rope comes off and you leave your prospective buildings. Tell me what you do or who you are outside of court that gives you the experience and knowledge and help you refresh to come back Monday or late Sunday to do your job.
So, again, I run my own business, so I am in the office pretty much 7 days a week. You can ask my wife that, because when I'm not around able to pick up the groceries, she reminds me of the same as well. As far as what I actually do, again, is a high amount of community engagement. Like I've indicated, going in, and it's not just been since I've announced I've running. I've been doing it for many, many years, going in the flood channels here in Southern Nevada, dealing with individuals that are facing housing security, working alongside, for instance, with the Just One Project on their monthly pop-ups for people dealing with food insecurity, going out there engaging with high school civics competitions called We the People, trying to get out there and help out the community know that we're here to help each other out and to further develop our future generations, something I take extremely important. Now the question becomes, hey, where does your self-help come in, your self-care? Because with all that time that's limited, I make sure to look for those avenues as far as meeting with, I'll be straight with you. I think sometimes counseling and therapy on my end has also been something that I found extremely beneficial to compartmentalize all the difficulties and things that we as a community continue to face. And these things collectively have helped me. And these are things that I do outside of the robe that when I come back on Monday, I'm ready to do it again and use those life experiences to follow the law, but also have that avenue of compassion.
Thank you. Obviously, I work all the time, including, of course, availability for search warrants and other things when I'm on duty for that, for our officers that call you at 2 a.m, etc. And have always, and for entirety of my career, spent my career in public service. I felt really called to do that. When you ask me what do I do outside of, and who I am outside of that, you know, the number one thing that pops in my mind are my 2 kids. Right? They keep me grounded. They have a special way of really throwing in your face, you know, the realities of life. And when you say take off the robe doesn't matter when you got 2 kids at home and they need mom, period. End of sentence, right? But it absolutely renews me. I am also a person of faith. You'll see me at church every Sunday. That is something for me personally that absolutely makes sure that I'm connected in a way not only to my community, but I obviously prayer is something that I personally turn to rejuvenate me. And then, of course, those associated activities with my church and with my kiddos. They are the things that brighten me back up, that give me the reason that I do what I do, because we want to have our communities of families be able to have safe places to really live the real life stuff, the good stuff with the kiddos. And that's the number one thing that rejuvenates me.
Frank Friends, Veterans of Politics. This will be the last question for this panel. We live in a digital age. Almost everything you do is either recorded on camera, on Facebook Live, on somebody doing World Star. So like 80% of the crime that you see is criming on tape. At what point do you as judges, or if you become a judge, do you say, yep, that's you. Yep, you did it. Speedy trial done. And stop wasting the taxpayers' time and money and everybody else's issues, and actually give justice to the people who were victimized on these videos?
Videos are obviously a great thing. And I don't mean to segue too much out of it, but boy, is AI changing things, right? That's going to be an interesting thing going forward. But if you're talking about like a quote unquote dead to rights case, I do believe in the process of due process. I represented an individual who was accused of raping various women and saying he was acting as an undercover vice officer. Government was sure, based upon six-pack witness identification and witnesses, that they got their guy. Through my investigation and my investigator, we were actually able to show that was not the right guy. We were able to get him released on a house arrest aspect, if you will, pending his trial. But through that process, we further developed. It was an ongoing heated contest with the government on this issue. And ultimately, the true perpetrator, who looked extremely similar to that individual, ended up raping another female. So I think we have to be very cautious. I understand justice delayed, justice denied aspect, but also making sure that the process of due process actually proceeds as going forward. Because there are those cases out there where we think, hey, we've got them dead to rights, and lo and behold, it doesn't happen. I experienced that firsthand through my client. I could tell you firsthand that does happen. Thank you.
That question, from a judicial standpoint, is very different than from a defense attorney standpoint. Because what I hear you asking is, why are you letting things be continued and delayed in your court? And from that perspective of, you've got all the information you need. I will tell you, we don't hold, unless it's a misdemeanor trial, those trials in my court. But there are things that we can do to ensure that our process doesn't drag on, which is what I'm really hearing from that question. And so the ultimate determination of whether that video is accurate, right? Whether that jury finds beyond a reasonable doubt that that actually may be the person that committed the crime and it's on tape, versus what the judge does to be able to get it in front of that jury, are two different things. And so I have absolutely had cases before me where there's been continuances, and sometimes it's needed. Folks are doing continued investigation, and due process has to be protected. And then there's a point that, as a judge, I say, this is a firm setting. Everybody be ready on this date. This is the date we're going forward on the preliminary hearing, and we will hold it that date. Absent some sort of extreme scenario, everybody be prepared. And those are the types of things we can do so that either victims of crime and other parties involved, even the defendants, aren't sitting here going, it's getting continued again, Judge. And that's what I've done in my court.
Okay. Thank you, judges. So and candidate, you're going to get 1 minute to tell the people why to vote for you, and then we're going to close it out.
Thank you again, everyone, for your time, and thank you to all of our servicemen, servicewomen, everyone that's watching. Again, my name is Lance Hendron. I'm running for Henderson Justice Court Department 3. I've been a Southern Nevada resident for well over 35 years with 18 years of legal experience. Everything that's come before the Justice Court, I've handled in some capacity, either as a private attorney or as a pro bono attorney helping out the community. I've done every single one of those and have experience every which way on these type of cases, and would bring that to the bench. I'm readily available. If you want to reach out to me, my cell number is 702-483-8181. My website is lance4judge.com. And also on social media, Facebook, it's Lance4Judge. I ask you to go and join the group. Any questions you may have, please reach out, let you know. And remember, Hendron for Henderson. Thank you.
Thank you. I'm asking for folks to reelect me. And when you ask why, the bottom line is experience matters. And I don't mean passive experience of number of years. I mean handling high, complex litigation issues in every aspect, both criminal and civil, including experts through trial and onwards. It is something that I've done by the thousands, and it's why I want to continue to serve. I have dedicated my entire career to public service. I've always felt like it was something that I was called to do, and I ask the public to help me continue to serve them, not only in a way that's prepared, but in a way that's just. Barbara Schifalacqua, I ask for your vote June 9th, Henderson Justice Court, Department 3. Thank you.
Thank you, Judge. Thank you, candidate. Thank you, panel and Facebook. We'll see you later.